Hello and welcome to Study IQ. I am your friend Rahul Saigankar. I hope you are in good spirits today. Our discussion today relates to National Green Tribunal. I'm quite sure you must have heard about NGT, right? Since its conception from 2010, in 2010, NGT started, and since that time, in the last 12 years, NGT has given some landmark judgments. We all know that climate change and global warming are a reality. Its adverse consequences are being taken very seriously across the world. In India, we have started so many initiatives. And NGT's role has become more and more prominent. It has given some landmark judgments related to Delhi government, the scrapping of the old vehicles, old diesel vehicles, the art of living judgment, Yamuna judgment, so many judgments by NGT. So the role of NGT has become more and more pronounced. In this discussion, we are going to talk about NGT, and there is a small suggestion which has come from Supreme Court, which actually becomes a fodder for you for answer writing. Now, if a question comes, how can the working of NGT be improved? One of the suggestions has been given by Supreme Court. The Supreme Court has aided you in your preparation. Supreme Court has given a suggestion to the center of considering of having NGT benches in each and every state. So in the first half of our discussion, we are going to talk about NGT. What is National Green Tribunal? If Supreme Court is suggesting that it needs to be there in every state, in how many states does NGT bench work? That will be understood, right? Apart from that, why Supreme Court has suggested this? We'll talk about the current matter which is sub judice. We'll talk about a case which is already there with the apex court. But in the second half of our discussion, we'll ask a very important question. Again, related to this discussion itself. In general, tribunals, right? Are tribunals a substitute to High Court, or are tribunals supplemental to the High Court? These are the questions that we'll try to answer in the second half of our discussion. Now, to get to know all this information, stay with me on Study IQ. And if you're preparing for competitive exams like UPSC Civil Service Examination or State PSC, do visit our website studyiq.com. Alternatively, you can also download our app from Google Play Store, where you'll get all the information about our courses. By subscribing to these courses, your preparation will be much sounder. Your probability of clearing the exam will increase for sure. And do remember to use the coupon code RAHUL33, capital RAHUL 33, without any spaces whenever you check out from Study IQ. Whenever you buy any course across Study IQ, you will get 33% discount if you use the coupon code RAHUL33. Right, let's begin the discussion by understanding the National Green Tribunal. What is NGT? Please remember, NGT is a specialized body. It is a statutory quasi-judicial body. NGT started with the National Green Tribunal Act in 2010. Right? Many other countries, especially New Zealand, had brought its own green tribunal, and we also followed the suit in 2010 to effectively and expeditiously dispose of the cases which are related to environment. NGT is mandated. I would say NGT strives for disposing of cases very quickly within 6 months of filing. And the NGT comprises of a chairperson, judicial members, and expert members. They shall hold the office for the term of 5 years, and they are not eligible for reappointment. Please remember this. Also, note this particular point, that an order, decision, or award of a tribunal, that is NGT, is executable as the decree of a civil court. That means they cannot award any criminal punishment, but it is like a civil court. They can order for some sort of compensation to be paid, some sort of fine, etc., but not as a criminal court. And please remember, in the NGT Act, NGT deals with cases specifically under 7 laws related to the environment in India. Now, this is something that I wish the aspirants remember, because many times question can come up: which of the following laws gives powers to the NGT, or NGT can try the cases under which laws? The Water Prevention and Control of Pollution Act 1974, Water Cess Act also, the Forest Conservation Act, Environmental Protection Act, Air Pollution Prevention Act, then there is Public Liability Insurance Act, please do remember this, and then Biological Diversity Act 2002. So these are the 7 laws from which the NGT derives the power, and they can try the cases under these laws. Please remember this. Apart from that, there is one more thing that you need to note about the National Green Tribunal. Its jurisdiction is connected to the environmental matters. Of course, it has come so that the load of the other courts, that means the High Courts and Supreme Courts, can go down. They also provide expertise with respect to environmental cases. Speedy environmental justice is one of the intention of National Green Tribunal. Again, they endeavor, that means they strive to finish off the cases within 6 months of filing. Again, no hard and fast rule that within 6 months it has to be disposed of, but they will try their level best to finish off or dispose of cases within 6 months of filing it. How many benches are there of the NGT? Please remember this. There are 5 benches of National Green Tribunal. The principal bench is in New Delhi, and there are 4 regional benches, one at Bhopal, one at Pune. Please remember these two specifically from exam perspective, Bhopal and Pune. Why? Because the High Court of Madhya Pradesh is not in Bhopal. The High Court of Maharashtra is not in Pune. Please remember this. But the NGT benches are in Bhopal and Pune. Apart from that, Kolkata and Chennai. These are the 4 regional branches. Apart from that, principal bench at New Delhi. So right now, NGT sits at only 5 places. And the language at NGT is English, of course. So do note all these things. Now let's come back to the case. I told you Supreme Court has given a suggestion to the center. Please consider having NGT benches at all the places. Supreme Court asked a question to the union government, why cannot National Green Tribunal have its benches in every state to enable the citizens to raise important issues of environment without having to travel hundreds of kilometers approaching just the 5 existing benches that we have? This was the question that was raised. Again, why this question? In what case? The case pertains to Madhya Pradesh High Court Bar Association challenging some of the provisions of the NGT Act 2010 itself. The Bar Association has challenged the National Green Tribunal Act 2010, where certain provisions give unbridled power to the center, especially with respect to establishment of the tribunal and fixing Supreme Court as the appellate forum. Now please remember, whenever a case is disposed of by the NGT, its appeal directly lies with Supreme Court. That means the high courts have been bypassed. Please remember this. Alright. Now, citing this itself, the association, that is the Madhya Pradesh High Court Bar Association, they underline that the principal bench of Madhya Pradesh High Court is at Jabalpur. But by using the extraordinary powers, the central government has set up the zonal bench at Bhopal. Apart from that, the law, National Green Tribunal Act 2010, it does not provide any sort of consultative process with Chief Justice of High Court for appointment of the judges, and it creates a lot of problems, especially for the people. If I want to file a case, right, I do not have a regional bench in my state. So I have to travel to the nearest benches where I can file a case. That's a problem for me. That has been highlighted by the association. And the Supreme Court has also observed in the arguments. Supreme Court said that the objective of establishing these tribunals, the quasi-judicial bodies, was to bring appropriate forum and bring the justice to doorstep of the citizens. And right now it is a problem. Apart from that, the Supreme Court bench also lamented that whatever cases are there with NGT, whatever cases that they dispose of, all the cases have been appealed at Supreme Court. So the Supreme Court load has also not reduced. That was the argument. And in this particular case, Supreme Court gave 3 days to both the parties, to the association as well as the central government. Again, central government's attorney, right, he argued that he will take up this matter with the center regarding setting up of the NGT benches at every state. Let us hope that it is done, and whenever it is done, we'll discuss that again. And written submissions had to be submitted within 3 days. And the matter is sub judice. We'll keep an eye on this. Again, the bigger issue here is this, what the association has challenged. Central government has extraordinary powers to set up a tribunal. Apart from that, central government also has a power to bypass the high courts. Now, in India, whenever you talk about judiciary, of course, there is Supreme Court here and there are high courts at state level. And along with high courts, there are tribunals, right? We know. And below the high courts, there are subordinate courts. There is subordinate judiciary. Now I'll write sub here so that you understand. Subordinate courts or subordinate judiciary. And there can be tribunals at this level also, because the states can also set up their own tribunals, isn't it? So tribunals can be equivalent to high courts. Tribunals can also be equivalent to the subordinate courts, right? But here we are going to talk about tribunals and their conflict with high courts. So let's first try to understand what are these tribunals. Tribunals, they were not originally part of Indian constitution. Please note it. Tribunals, the concept of tribunals is rather Western. It comes from UK. In fact, tribune was quite predominant during the ancient Greece proceedings, right? From there itself, the idea has come. Tribunal is like adjudication outside the courts. Tribunals were introduced in Indian Constitution in 1976 via the 42nd Constitutional Amendment Act on the recommendations of Swaran Singh Committee. Ultimately, tribunals started to come in 1980s. If I'm not wrong, in 1985, many state administrative tribunals did come. And the intention of tribunals is to provide speedy justice, speedy, inexpensive, and decentralized adjudication of disputes. Again, tribunals are set up as a specialized quasi-judicial body or a quasi-judicial court to dispose of specific cases. Where does the parliament derive its powers? It derives its powers from Article 323A and Article 323B. Right? Please remember these. Under Article 323A, the central government and the state governments can set up administrative tribunals. Administrative tribunals means something related to you. Now, when you get into service, if you have any problem with the government regarding your transfer, posting, etc., you can directly approach to the administrative tribunal, central administrative tribunal, or respective state administrative tribunals. These are the examples under Article 323A. But Article 323B gives immense powers to the central government to set up tribunals for different subjects. For example, there has been National Green Tribunal under Article 323B itself. There is Armed Forces Tribunal, there is Income Tax Appellate Tribunals. In fact, at one point of time, India had more than 50 tribunals. And in recent years, the NDA government has rationalized and they have merged many tribunals to reduce their numbers, right? So I hope by now you've gotten an idea of why tribunals were created. But there is something specific about the tribunals that you need to understand before we answer the question, can they be substitute to high courts? See, tribunals are different. On one side, there is Supreme Court, there is High Court, and there are subordinate courts, right? The Supreme Court judges appointment is done by President of India. The High Court judges appointment is done by President of India. The subordinate courts, right? There, the judges appointment is done by the respective governors of the states. There are procedures mentioned. We know that. But when it comes to tribunals, the powers related to tribunals are completely with the executive. Please remember this. And tribunals are quasi-judicial agencies which are created by a statute. For example, NGT by the NGT Act 2010. Specific powers would be defined. How can they try the cases, which kind of cases they can take up. For example, under NGT, we saw 7 laws under which they can take the cases. The statute will define it. Apart from that, the tenure, the terms, the conditions of services of the members of tribunal, they are all in the hands of executive. And please remember, whenever we talk about tribunals, there is specialization. So tribunal will have judges, that means they will have judicial members as well as non-judicial members. So I hope you understand the problem. What is the problem here? That the executive, when I say executive, it is basically the government, central government or the state government, they will have a sway in terms of who is going to become the judge here. Who is going to become the judge for environmental case? Who is going to become the judge for, say, income tax case? So the executive or the government of the day will decide these people. That is the major problem. I hope you understand that towards this judiciary, the appointment process is quite clear. The president or the governor appoints, but for tribunals, people are appointed by the respective governments. Now here we are talking about NGT, it is the central government. Clear? That is the major issue. Now apart from that, tribunals have something specific. Now tribunals cannot declare a law unconstitutional. Please remember that tribunals cannot declare a law ultra vires of the constitution. That power is with High Court, Supreme Court, we know that. Tribunals can also be a party to a dispute. Now, have you ever heard of High Court of Madras or Madras High Court versus someone? The courts cannot be a party. Please remember that. It's always the state which is the party. State means, say, state of Karnataka, state of Madhya Pradesh, or the Union of India. That is a party to the case, but courts are not a party. Tribunals can be a party to the dispute. Apart from that, the tribunals try to dispose of the cases very, very quickly because they are not bound by the same logic that goes through the normal judicial. The Supreme Court, High Courts, and the subordinate courts, they all follow the civil procedure courts. But these tribunals follow principles of natural justice. That is why they are able to dispose of the cases very, very quickly. Now, I hope you understood the difference, and that is the main problem. That is the main issue here. Tribunals, their control, or tribunals can be controlled by the government. That is the major issue. And that is why there is always a debate that are tribunals an alternative to the high courts? Please note that there are some case references which are very important for you so you understand what is the situation as of today. I told you, tribunals were not included in the Indian Constitution originally. They were added in the 42nd Constitutional Amendment Act. Now, after it came in 1976, almost 10 years later, many tribunals came up which was challenged. And in P. Sampath Kumar versus Union of India case 1986, the Supreme Court held that it is constitutionally valid for Parliament to create alternate institutions to High Court. That means in the P. Sampath Kumar case, the Supreme Court held that tribunals are like alternate to the High Courts. But this situation was little bit reversed in the L. Chandrakumar versus Union of India case. Please remember this. L. Chandrakumar case is a big precedent in which the Supreme Court enunciated that tribunals are supplemental to High Court. Please remember, tribunals are not substitute to the High Court. They supplement the High Court. They help the judiciary in reducing the pendency. They help the judiciary in disposing of the cases where specific knowledge is needed. They are not substitutes, right? Supreme Court has also given clear guidelines that tribunal which substitutes a High Court as alternative institutional mechanism must have the status of High Courts. Again, such tribunals which act as a court of first instance, again, their appeal will also lie in the High Courts. Please remember this. Apart from that, only persons with judicial experience should be appointed to such tribunals which act as alternative institutional mechanisms. So these are some of the guidelines that are given in L. Chandrakumar versus Union of India case. And to bring uniformity in administration, a separate independent mechanism should be set up to manage the appointment of tribunals. This was suggested in the L. Chandrakumar case, but this has not been done till now, right? So as of now, what is the situation? Are tribunals alternate to High Courts? L. Chandrakumar case says that they are not substitutes, they are supplemental. But yes, in some provisions, they can bypass the High Courts also. For example, NGT is prime example, again, on which the Supreme Court will give us more and more clarity. But as of now, please remember, tribunals are not supplemental to High Court, they are substitutes. But in certain statutes, for example, NGT case in point, where the appeal directly lies with Supreme Court, the matter is still sub judice. Whenever the issue becomes more clear, we'll talk about that again. I hope this idea is clear. We'll keep an eye on this, and whenever update comes, we'll discuss again. That is it right now in this discussion. Thank you for watching this. Jai Hind.